Welcome back to Immigration Desk, where we cut through the noise and bring you the immigration information that matters most to your life and your family's future. Today, I'm here to guide you through something that every single green card holder in America needs to clearly understand right now. What I'm about to share with you is detailed, it's significant, and it will require your complete attention because it affects millions of lawful permanent residents across the United States. If you've been a green card holder for 5 years, 10 years, or even 20 years, and you believed your permanent resident status was truly permanent, then I need you to stay with me throughout this entire video. The landscape is changing in ways that most people have not fully grasped yet. We are talking about a complete transformation in what it means to hold a green card in the United States. This is not simply another policy adjustment or a minor tweak to existing immigration regulations. This represents a fundamental reimagining of the relationship between the United States government and its lawful permanent residents. The law we're discussing today is called the Secure Paths and Integration Act of 2025, and it represents one of the most sweeping overhauls of immigration policy for green card holders in an entire generation. Congress has passed this legislation with the stated objective of modernizing the immigration system and promoting what they call deeper civic and economic integration of permanent residents into American society. But what does that actually mean for you? What does it mean for your daily life, for your family, and for your long-term plans in this country? That's exactly what we're going to break down together today, step by step, requirement by requirement, so that by the end of this video, you will understand exactly what is coming and exactly how to prepare. Before we move into the detailed specifics, let me give you the single most important concept you need to understand about this new law. For decades, a green card has functioned as what immigration experts describe as a passive status. In simple terms, once you obtained lawful permanent resident status, as long as you did not commit serious crimes, did not abandon your residency by staying outside the United States for extended periods, and renewed your physical green card every 10 years, you were essentially secure. Your status was stable. You could live your life, work your job, raise your children, and pursue your American dream without constantly looking over your shoulder or worrying about your immigration status. That era is now coming to an end. The Secure Paths and Integration Act of 2025 shifts the green card from a passive status to what can only be described as an active status. This means that maintaining your lawful permanent resident status will no longer be as simple as avoiding major problems. Instead, it will require ongoing proactive engagement with a new system of requirements, documentation submissions, and periodic reviews. Your green card is no longer just a destination you reached after years of waiting and processing. Under this new framework, it becomes more like a journey with mandatory checkpoints along the way. Checkpoints that you must successfully navigate every few years in order to maintain your status. Now, I can already sense that some of you may be feeling anxious or concerned hearing this. Let me address that directly before we continue. Yes, this is a significant shift. Yes, it will require preparation and effort. But panic is neither productive nor necessary. What is necessary is understanding, preparation, and thoughtful action. That is exactly why we are here today, and that is why I am going to walk you through every aspect of this new law in clear, practical terms so you know what to expect and how to get ready. Let's begin by understanding the stated purpose behind this legislation. Knowing why Congress says they passed this law will help you better understand the structure of the new requirements. According to its supporters, the Secure Paths and Integration Act has two main objectives. The first objective focuses on modernization and efficiency. The government wants to digitize immigration records more comprehensively and implement what they describe as a more streamlined, data-driven approach to immigration oversight. This involves improved technology systems, more accessible online portals, and faster, more efficient processing mechanisms. The second objective, and this is the one that directly affects your everyday life, centers around integration. Lawmakers argue that this new framework ensures that long-term permanent residents are more deeply connected to their local communities, more engaged in American civic life, and placed on a clearer, more structured path towards citizenship if they decide to pursue naturalization. Supporters claim this system will help permanent residents feel more rooted in American society and will create clearer expectations about what it means to be a contributing member of the community. At this point, you might be thinking that all of this sounds reasonable in theory, but what does it actually require you to do? That is the critical question, and that is where we now turn to the specifics. The practical impact of this law is that it places a new and significant administrative responsibility on every single green card holder in the United States. It establishes new documentation requirements, new responsibilities, and new checkpoints that simply did not exist before. At the center of this entire law is something called the Continuous Status Review, commonly referred to as CSR. This is the mechanism through which all of these new requirements will be implemented and enforced, and it is essential that you clearly understand how it works. The Continuous Status Review is a mandatory check-in process that every lawful permanent resident will be required to complete on a regular, ongoing basis. And when I say regular, I mean every 3 years. Yes, every 3 years you will need to undergo this review process. This requirement is entirely separate from the current 10-year green card renewal process. Your physical green card will still need to be renewed every 10 years, just as it always has. The CSR is an additional layer, a completely new requirement added on top of the existing system. Think of it as a periodic re-verification of your eligibility to maintain permanent resident status. It is not simply confirming that your green card is valid. It is confirming that you, as an individual, are meeting an expanded set of criteria for what the government now defines as an active, engaged, and integrated permanent resident. The CSR will primarily operate as an online process, aligning with the modernization goals I mentioned earlier. You will access it through official government portals and digital systems. However, do not assume that because it is online, it will be quick or simple. This is not just logging in and clicking a few boxes. The CSR will require submission of substantial documentation that has never before been required on such a frequent and recurring basis. You will need to gather records, obtain third-party verification, and compile a comprehensive package of evidence showing that you meet the new standards. So what exactly are these new standards? What type of documentation are we talking about? The Continuous Status Review focuses on 2 primary areas that every green card holder will now be required to address. The first is what the law calls the civic integration requirement. The second is a stricter and more frequent verification of your financial self-sufficiency and your continuous residency inside the United States. Let's carefully break down each of these components so you fully understand what will be expected from you. The civic integration requirement is one of the most new, and honestly, one of the most debated elements of this entire law. It is something that has never existed before in this form for lawful permanent residents in the American immigration system. In practical terms, it means that during each 3-year review period, you must demonstrate that you have been actively participating in American civic life. This goes beyond simply living here and working here. It requires proof that you are engaged in your local community in specific and measurable ways. Under the law, you are given 2 options to satisfy this requirement, and you can choose whichever path better fits your personal situation. The first option is community service. Specifically, you must complete and provide verification for 40 hours of community service during each 3-year review period. The service must be performed with a registered nonprofit organization, a public school, or a government-recognized community entity. If you break that down, 40 hours over 3 years equals roughly 13 to 14 hours per year, about 1 hour per month. The government's position is that this is a manageable commitment designed to encourage permanent residents to give back to their communities and build stronger local connections. The second option is completing a government-certified American Civics and Governance course. This will not be the simple civics test that individuals take during naturalization. Instead, it will be a more comprehensive educational program covering the United States Constitution, the structure of government at the federal, state, and local levels, and the rights and responsibilities of both citizens and lawful permanent residents. These courses are expected to be offered online and through approved educational institutions across the country. Once successfully completed, you will receive an official certificate. That certificate must then be submitted as part of your continuous status review documentation. Now, what is the government's reasoning behind requiring either community service or a civics course? Supporters argue that the goal is to move beyond the traditional view of permanent residency being solely about physical presence. They want to foster what they call a deeper sense of belonging and shared responsibility among long-term residents. The idea is that by participating in volunteer work or gaining a stronger understanding of American civic institutions, permanent residents will feel more connected to the country, will be better prepared if they decide to pursue citizenship, and will become more engaged members of society in general. On the surface, that sounds reasonable. Community involvement and civic education are positive values, but we must also consider the practical realities and challenges of applying this requirement to millions of individuals with very different life circumstances. Consider a single parent working 2 jobs just to support their children. For that individual, finding 40 volunteer hours, even spread over 3 years, could be extremely difficult without sacrificing income or family responsibilities. Consider elderly permanent residents with health conditions or mobility limitations. Consider individuals with disabilities who may face barriers to traditional volunteer work or structured classroom environments. The law does include waiver provisions for hardship, disability, or other special circumstances. However, the details regarding how those waivers will be granted, what documentation will be required, and how accessible the waiver process will be are still unclear and will depend on future regulations. There are also major administrative questions that remain unanswered. Who determines which nonprofit organizations qualify to verify service hours? What oversight systems will prevent fraud or inaccurate reporting? Will the civics course be available in multiple languages? Will there be fees for the course? And if so, how much? These details matter. They will determine whether this requirement operates as a reasonable civic engagement tool or becomes an overwhelming administrative burden. Now let's move to the second major area of the continuous status review: financial self-sufficiency and continuous residency. At first glance, these concepts may seem familiar. Financial stability and avoiding public charge concerns have long existed in immigration law. However, what changes under this new law is the frequency and level of review. Previously, financial self-sufficiency was primarily examined at the time you applied for your green card. After approval, there was no scheduled recurring requirement to prove financial stability unless you applied for citizenship or faced specific legal issues. Under the new framework, every 3 years, as part of the CSR, you will likely need to provide documentation proving your continued financial stability. This will most likely include submission of tax returns for the previous 3 years. Tax returns provide official proof of income, employment, and overall financial activity. You may also be required to declare that you have not received certain federal means-tested public benefits during the review period. The exact list of benefits that could impact your review is still being defined through regulatory guidance. This is where close attention becomes extremely important. The United States has many different public programs. Some are universal services like public schooling or emergency medical care. Others are insurance-based programs such as Social Security or Medicare. And then there are means-tested assistance programs designed for low-income households, such as food assistance or housing subsidies. The question is how the government will evaluate short-term assistance versus long-term reliance. Will temporary benefits during a job loss be treated differently from long-term dependency? Will benefits received by your children count against you? These details will significantly affect many families. The continuous residency portion of the review will also receive more formal scrutiny. The long-standing rule has always been that spending too much time outside the United States can lead to abandonment of permanent residency. Generally, being outside the country for 1 year or more without proper authorization can put your green card at risk. That fundamental rule remains. What changes is that the CSR creates a formal review of your travel patterns and ties to the United States every 3 years. You will likely need to provide documentation demonstrating that you maintain your primary home in the United States. This may include proof of employment, property ownership, lease agreements, utility bills, U.S. bank account activity, and evidence that your immediate family resides with you in the country. The purpose is to prevent individuals from living primarily abroad while keeping a U.S. green card as a backup. If concerns arise during your review, the law introduces a new probationary status. This probationary period would give you time to correct deficiencies, submit additional documentation, or address compliance issues. However, failure to resolve problems during probation could ultimately lead to removal proceedings. This probationary concept introduces an entirely new level of administrative risk for permanent residents. In the past, maintaining your status was relatively straightforward as long as you avoided serious violations. Under this system, administrative compliance becomes an ongoing obligation. Now, given everything we've discussed so far, the most important question becomes, what should you be doing right now? First and most importantly, do not panic. The law's effective date is January 1st, 2026, and implementation will occur in phases. There will be guidance issued before reviews begin. Second, begin organizing documentation immediately. Start building a structured file system. Save your tax returns, employment verification, pay stubs, lease or mortgage documents, utility bills, travel records, and volunteer documentation. If you already volunteer, request written confirmation of your service hours now. Do not wait until review time. Third, rely only on official information sources. Regularly check USCIS announcements. Follow verified updates from Immigration Desk. Avoid rumors circulating on social media or messaging apps. Fourth, if you have complex circumstances, public benefit usage, extended travel, health limitations, prior immigration issues, consult a qualified immigration attorney for personalized advice. This law transforms the green card from a largely stable status into one that requires active, ongoing participation and documentation. It is a major structural shift. But preparation is power, organization is protection, knowledge is security. Thank you for trusting Immigration Desk to bring you this in-depth explanation of the Secure Paths and Integration Act of 2025. If you found this information valuable, please like this video, share it with other green card holders, and subscribe to Immigration Desk so you don't miss future updates. In upcoming videos, we will provide step-by-step walkthroughs of the continuous status review process once official forms are released. We will also launch a full naturalization series covering the citizenship application, biometrics appointment, interview process, civics test, and oath ceremony. Leave your thoughts in the comments. How do you feel about these changes? What concerns you most? What questions should we address next? Until our next video, stay informed, stay prepared, and remember that knowledge and preparation are your strongest tools when navigating changes in American immigration law. This is Immigration Desk, and I will see you in the next video.